Judgment in the matter of Daly against His Majesty's Advocate and Keir against His Majesty's Advocate.
The appellants in these cases were convicted of rape and other sexual offences. In this appeal, they ask the Supreme Court to decide whether they received a fair trial, as required by Article 6 of the European Convention on Human Rights. The appellants contend that their right to a fair trial was infringed because at their trials they were unable to lead evidence or to question the complainers or other witnesses about the complainers' credibility or previous sexual behaviour. In Scotland, evidence of this kind can only be led at trials for sexual offences if it's relevant at common law and admissible under sections 274 and 275 of the Criminal Procedure Scotland Act of 1995. Section 274 imposes a general prohibition on the introduction of evidence or questioning which concern the character, behaviour or sexual history of a complainer. Section 275 allows such evidence or questioning where the court is satisfied that the criteria specified in the legislation are met. Sections 274 and 275 exist to protect the complainer from unfair and intrusive questioning and to prevent the jury from being improperly influenced by evidence that is irrelevant to the charge against the defendant. The first appellant, Mr Daly, was convicted of the rape of the first complainer when she was between 5 and 7 years old, and of the violent and sexual abuse of the second complainer when she was between 6 and 12 years old. Mr Daly appealed against his conviction. He argued that his trial was unfair because the Crown did not charge him with the first complainer's further allegation that he had raped her when she was 13 years old and that she had become pregnant as a result of a rape and had given birth at her grandmother's house. Mr Daly claimed that this allegation was false because a doctor who examined the first complainer concluded that it was highly unlikely that she had given birth to a full-term baby, although an earlier miscarriage was possible. Mr Daly said that because he was unable to raise this allegation at his trial, he was prevented from showing the jury that the first complainer was not credible or reliable. The second appellant, Mr Keir, was convicted of sexually assaulting the complainer at his home address while she was intoxicated, asleep, and incapable of consenting, and of raping her when she awoke. Initially, Mr Keir was also charged with raping the complainer in a pub toilet earlier the same evening and with sexually assaulting her during a taxi journey on the way to his house. However, the trial court granted the Crown's application to drop these additional charges after the complainer was questioned about CCTV footage of the evening in question. Before his trial, Mr Keir made an application under Section 275 in which he sought to introduce evidence of consensual sexual activity between him and the complainer earlier in the evening, including the events shown in the CCTV footage. This part of Mr Keir's application was refused, and he went on to be convicted at his trial. Mr Keir appealed against his conviction on the basis that his trial was unfair. He contended that the Crown should not have been allowed to drop the additional charges and that the trial court was wrong to refuse his Section 275 application. The Supreme Court unanimously dismisses the appellant's appeals, but it finds that the Scottish courts should modify their current approach to the admission of evidence in trials for sexual offences, as it is so restrictive that it is liable to infringe defendants' rights under Article 6 of the Convention. However, on the facts, both Mr Daly and Mr Keir received a fair trial. The court begins by holding that the Crown's decisions as to the charges against the appellants did not affect the fairness of either trial. In both cases, it was open to the defence to lead evidence on matters not covered by the charges, provided it was relevant at common law and admissible under Sections 274 and 275. The proper target of the appeal is therefore the law of evidence. The court goes on to consider Scott's common law and practice prior to recent developments. It explains that, generally speaking, relevant evidence is admissible at trial. The courts may exclude relevant evidence which concerns a collateral fact or issue to avoid a distracting and disproportionate inquiry into peripheral matters. Evidence bearing only on the credibility of a witness has usually been considered to be collateral and so inadmissible, but it may be admitted if the evidence has a bearing on a fact in issue in the case. The distinction between inadmissible evidence, which is concerned only with the witness's credibility on the one hand, and admissible evidence, which is also relevant to a fact in issue on the other hand, is particularly difficult to draw in trials for rape and other sexual offences involving adults. That's because the offence generally takes place in private with no other witnesses present, so the credibility of the complainant's testimony is usually the decisive issue at the trial. Next, the Court considers the modern development of the law, including the introduction of sections 274 and 275. The Court explains that those provisions do not impose an absolute prohibition on the introduction of evidence or questioning which concern the character, behaviour, or sexual history of the complainer. Rather, the legislation recognises that the relevance and probative value of evidence of this kind will depend on the circumstances of each case. It therefore gives trial judges the discretion to allow such evidence and questioning to be introduced where it is required in the interests of justice. The legislation creates a balanced scheme which is capable of being applied compatibly with the Convention right to a fair trial. Recently, however, the High Court of Justiciary, in its capacity as an appeal court, has developed the common law concepts of relevant and collateral evidence so that evidence concerning the complainer's credibility or previous or subsequent sexual behaviour is almost always excluded from trials for sexual offences, with the result that trial judges do not reach the stage of exercising the discretion conferred by sections 274 and 275. The Supreme Court holds that this approach is liable to result in violations of defendants' rights to a fair trial under Article 6 of the Convention. The purpose of a criminal trial is to determine whether the defendant is guilty of the crime with which he has been charged. It's fundamental to our conception of justice that innocent persons must not be convicted. This principle underpins Article 6 of the Convention and protects both individuals who are accused of crimes and society as a whole. Article 6 guarantees a fair trial so that the defendant can present a full defence to the charge against him. To do this, the defendant needs to be able to call evidence which is relevant to establish his defence and to challenge the evidence called by the prosecution. Excessive restrictions on the evidence or questioning which may be led at trial can therefore be incompatible with the right to a fair trial. That is the situation which has been brought about by the recent development of a common law by the Appeal Court. The Supreme Court explains in detail, with references to the relevant judgments of the European Court of Human Rights, why the approach adopted by the Scottish courts has become too restrictive. It should be emphasised that the legislation enacted by the Scottish Parliament in sections 274 and 275 is not the problem. It follows that the Scottish courts are under a duty to modify their current approach, since they are required by Section 6 of the Human Rights Act 1998 to act in a way that is compatible with the rights guaranteed by the Convention. However, there was no infringement of the appellant's Article 6 rights on the facts of the present cases, so their appeals are dismissed. In Mr Daly's case, the first complainer's allegation that he had also raped her when she was 13 could only be relevant insofar as it might bear on her credibility. It was unclear whether this allegation was false on the material available to the trial court. Ascertaining the truth would have required the court to investigate an allegation of rape which did not form part of the charges, prolonging the trial and distracting the jury from its primary task. In Mr Keir's case, evidence of the consensual sexual activity between him and the complainer earlier in the evening could potentially have been relevant to the jury's assessment of the complainer's state of mind at the relevant time. However, its probative value was limited because on the facts of the case, it could not help the jury decide which of the completely different versions of events given by the complainer and Mr Keir was true. Its probative value in those circumstances was outweighed by the risk that it might prejudice members of the jury against the complainer and so distort the fact-finding process.